has its own problems. So you may just find yourself arrested at that point, and then having made arrangements to have your interview or chat to the police for an hour, then go on with your daily life, you may just find yourself at the wrong end of the law and in custody. So that's the difference. But the basic difference is the one, you're under the control of the police, and the other one you're not. You can walk out whenever you like.
Yeah. And can I also, perhaps when we're talking about an invitation to answer questions or attend either police station, there are other institutions, aren't there? Because I certainly remember as a prosecutor years ago, I used to do things like read through a lot of interviews where people had been questioned by, for example, Social Security officials for benefit fraud or allegations of benefit fraud, or even things like the RSPCA for potential animal cruelty offences. So it's not just the police, is it, who can call you for an interview where there could potentially be some criminal proceedings that follow from your questions that you're asked. Is that right? That
is correct. It's most, if not all, quasi-government or branches of the government that can call you for an interview under caution. It's different to just calling in for a chat.
Chat, indeed.
And as you say, social services for benefit fraud, immigration services, there are the RSPCA.
Yes.
There are numerous organisations that can call in. The city councils can call you in. Taxi licensing authorities can call you in. There are the Department of Works and Pension. There are numerous different organisations within the system that can call you in if they suspect that you've committed an offence, or if you can assist them in their inquiries.
Yes, because sometimes it might not necessarily be that you are a suspect. There could be some potential issues, but of course they're still in the investigation stage. So they may want to just simply ascertain some information for you.
Yes, you may just be a person of interest, or they may think you may have information that may assist them with their investigation. So in that sense, that's most likely where you'll be invited, is if they believe that you can assist them in their inquiries and investigation. If they believe you to be a suspect, for which there's evidence, you most likely will find yourself being arrested.
Okay. And so, since we talked about arrest, at the point when you're arrested, wherever that may be, what would you suggest or advise people are their rights at that point?
Well, at the point of arrest?
Yes.
Well, at that moment, once you're arrested, you're under the control of the police officer, as I said. Is that my advice would be is that to comply with what the police officer is requesting. And the reason why I say that is, it's again, something that could be quite innocent could turn quite nasty very quickly, and you find yourself at the wrong end of a much more serious criminal offence. But once you've been arrested, the officer needs to explain to you why you're being arrested.
Right.
Okay. So the explanation must be there. They can't just take you off the street. There must be some reasonable suspicion or reasonable cause for an officer to call you over and say to you, look, what is your name, what is your address, what's your date of birth, which is what they can do. But only if there is reasonable cause for them to do that. They can't just randomly choose you because of you're a youngster, your age, your race, your religion, or whatever the case may be, and say, you come here, give me your name, address, and date of birth. That can't happen. There has to be some underlying reason for them to do that. And once the reasonable cause is there, then they've got the right. That whatever they do from there is lawful. Anything before that will be unlawful.
Yeah. I think sometimes when we've seen, haven't we, whether it be anecdotally or in our own careers, where people have been arrested by the police and they challenge the police, or even though the police may give an explanation as to why the person's being stopped and why they're being arrested on suspicion of whatever the offence is. Perhaps sometimes some people would I think human instinct, I have to say, sometimes will say, well, what for? I haven't done anything. No, I'm not going with you. No, you can't arrest me. Almost as though there is some right to challenge the actual arrest process. What again, would you say about that? Because again, I think it's instinctive for people sometimes to simply say, well, what are you talking about? Especially if the scenario is that they don't know what the police are talking about and they haven't done anything wrong.
Now, as I said, the police must give you a reason before they arrest you. There must be a reason. reason for it. And they should give you a clear reason as to why they're arresting you, not, as I said earlier, because of your age, the way you dressed, the way you walk, the way you talk, etc. There must be a clear reason of committing some sort of form of offence, or you assisting them in some way in an investigation. But it's quite natural for someone that's just been accosted, if I can use that term, in the street by an officer. Say, come here, give me A, B and C personal information, for you to say, no, I've done nothing wrong. That's fair enough. But once the police officer says, okay, but I just saw you, or I believe, or I think that you may be involved in, then the explanation has been given. Now, what we must understand is that the officer doesn't have to see you do something. So physically watch you commit an offence for him to have reasonable cause. It may be an intelligence report that they got to say that Mr. X has been involved in this criminal offence and we're looking for him. Officers from the investigation department would like to speak to him. So there's the reasonable cause, is that someone within the police is suspecting him of committing an offence for which there must be some form of evidence, and the officer will arrest you. So yes, but my recommendation is not to resist. Ask, question.
Yes.
If the officer doesn't explain the reason for the stopping and the questioning, ask for a reason. But once he's given you a reasonable cause to stop you, my suggestion would be comply.
Yes. Because again, that's another scenario that could lead into other problems if you don't comply.
We've got resisting arrest, we've got obstructing an officer in execution of his duties, and more recently with the law that's come out not too long ago with assaulting an emergency worker.
Yes.
And these attract custodial sentences, prison sentences, and it's just not worth it.
Yeah.
Just not worth it. You will be taken off the street by force by that officer or that officer and colleagues, and you'll be kept in custody until they've completed their investigation, or for the 24 hours at least. And then you may be released or you may be taken to court. It's just not worth it.
Yeah. Then have you got any examples of scenarios that you've come across or anecdotal tales of things like that where people have resisted arrest and sort of the consequences that have happened as a result of that?
One off the top of my head is quite a simple one with a youngster who got off a train, a tube. He had no Oyster card on him. We said he had lost his Oyster card. He was stopped by two British Transport Police officers. They asked him if he had a valid ticket. He said he had lost his Oyster card. The officer said fine and left it at that. Said, have you got money? Yes, I do. Please purchase a ticket. Now he's committed an offence, fair evasion.
Yes.
The offence has been committed.
Yes.
The officers follow him to the ticket machine. He tries to purchase a ticket at the first machine. Officers are standing close by. Now he's committed an offence, so they're at the ready, surely.
Yes.
And he starts saying to the officers, why are you standing so close? Now get away from me. Stand back. Now, that is not helpful to both the officers, because the officers are now thinking, most likely, if something is going to happen, he's going to try and bolt and run. And he, for whatever reason, is thinking, hang on, if I'm going to bolt, I need space.
Yes.
And I don't want these officers to see what I'm doing. But in any event, to cut a long story short, he goes to the machine next door, gets himself a ticket, turns around and flashes his ticket to the police. So that's all fair and well. And the officer says to him, can I have your name, please? And that's where it starts. What for? No, you can't have it. I want your address. I'm not giving it to you. And from there, it escalated very quickly into a scuffle, where one of the officers at one point just said, after about 5 minutes of wrangling with this youngster about, look, we're entitled to it, saying to him, this is one of the lowest forms of offences you're going to commit in your life, is fair evasion. It's not worth it. The officer saying to him clearly, it's not worth it. To the point where the officer says, right now I'm arresting you for fair evasion.
Yes.
And the scuffle starts.
Yes.
He finds himself at the wrong end of a magistrate's court, which has gone up to, or went up to a Crown Court for assaulting two emergency workers. Facing a possible custodial sentence. It's just not worth it. Now, clearly that is a pretty straightforward scenario. But that is not uncommon, where the police officer says, "Come here, I think, or I believe you've done something wrong," and they get told no.
It reminds me, actually, as you say that, of a scenario that I had, I think, where I was actually the prosecutor, where the gentleman was arrested at home because he'd been alleged to have assaulted his partner at home. And what then happened was then the police turn up, of course, to arrest him. And then he resists and says, "I haven't done anything, ask her, I haven't done anything." But then because the police are saying, "Well, no, we're not going to ask her here. It's not appropriate. You don't dictate to us how this is to be done. It's our investigation. You must come to the police station." He ended up in a scuffle fight with the police officers, so was arrested for assault PC. Got to the police station, went through the process, was asked questions, etc. So got no comment throughout all of his interviews. So all of that, you think, right, okay, he's trying to sort of see how things lie, how the land lies. So by the time I get involved in the case, it's now in the magistrate's court. We didn't go up to Crown. And he, at court, after he pleaded not guilty, we had a trial, his partner refused to give evidence. She said she wasn't going to. So we then had to think, what are we going to do? So we decided, well, she's not going to make too much of a fuss of this if she doesn't want to pursue it, which a lot, unfortunately, domestic violence cases, as you know, end up that way. What we ended up doing was we just pursued the assault PCs. Because they're more serious offences anyway, given the level of injuries of his partner versus the police officers. And it was more likely, frankly, that those offences were able to go the full way than the domestic violence offences where, you know, somebody's torn between whether she's giving evidence against her partner or not, or whether she's going to blame herself. Because I think when I certainly had some discussion with the witness, her position was that, well, I hit him as well as him hitting me. So then you've got the blurred lines, haven't you, between whether, hang on a second, is this a case that has a reasonable prospect of success, given that she's also admitting that she assaulted him, and not just pure self-defence, that she actually was the aggressor as well as part and parcel of the whole thing. So then we ended up in a scenario where, as I said, we just ended up prosecuting him because of the police officers.
That's a very good example of something that would or could have run its natural course and died a natural death after a short period of time. It's landed up with someone getting a criminal conviction for some serious offences. Yeah, exactly. Which was unnecessary.
Yeah, and I think also it is taken quite seriously by the courts, isn't it?
Taken very seriously.
When there's assault PC, because they think this is an officer in execution of their duty. You've not been able to prove that the officer did anything wrong. The officer did everything he's supposed to have done in terms of arresting you, giving you at least a reasonable excuse as to why he's arresting you, going through the whole what we call PACE, so going through the right procedures, and then in the end, because of that, he gets no thanks for what he's doing in terms of keeping the public safe, and then ends up, in fact, being assaulted by you. And so the authorities, I know, certainly the courts do, take quite a dim view, don't they, of those types of cases.
That's why it's been made a separate offence now. The charge is not being assaulting a police officer in the execution of his duty, which is a serious offence. It's now assaulting an emergency worker. So it covers ambulance staff, fire department staff, etc. Yeah. What a lot of people also forget is that police officers nowadays, the 99%, if not all of them, walk around with these video cameras. So it's most likely going to be all on camera, whatever happened. And what is forgotten is that the police officer doesn't have to have a physical injury. He doesn't have to have a black eye, a cut lip. He could pull a finger, get a bruise, a strained muscle. That's an injury he had before he dealt with you. And it's because of your actions. It's the old but-for test. But for your actions, he wouldn't have sustained the pulled shoulder, the painful muscle, or whatever the case is. But nonetheless, it's an assault.
That reminds me, actually, when you use the word assault and describe what could be or amount to an assault. I remember when I was doing my training many years ago that one of my senior colleagues who I went to court with was dealing with an assault case or a chain of events where there are a number of assaults by one gentleman all in one day. And in the end, he pled guilty to assault by beating because he used a bunch of flowers to hit his girlfriend. And that's enough, isn't it? I mean, as you say, there doesn't need to be an injury, there doesn't need to be anything. It's unlawful touching. So it is where you place your hand or place whatever part of your body it is on another person where the other person hasn't given you the right to do so. It can be an assault,
that's
can't
an
it?
assault.
Yeah, exactly.
And that's the distinction between common assault and
Yes.
assault by beating.
Yes.
The common assault is no touching, where the other one will be, the assault by beating will be there's touching of some degree.
Yes.
And it can be a poke.
Yes.
That will be the
That's
beating.
enough for an assault,
That's enough
isn't it?
for an assault.
Yeah, so
by
people
beating.
need to be careful, whether it's the police or other authorities or whoever it is, that you need to be careful that you are not finding yourself wanting because of the way in which you've acted. Where, as Len has said, it starts off as something quite minor, something perhaps insignificant, and then it becomes something quite serious. Yeah, so we do urge people to be considerate of their own self, if not of anybody else, when you're confronted by an officer and he asks you questions. Answer the questions. If you have to go to the police station, then do. It's not an option. It's not optional. It's not for you to decide, well, I feel like going, no, I don't feel like going, okay? And then you can always deal with it from there, can't you, Len?
Yes.
Once you get to the police station, you speak to a lawyer at the police station. Then if it was an arrest that, for example, was unlawful, if there was no justifiable cause, etc., those can all be dealt with, but everything has its time, doesn't it?
What we've got to remember as well, that if an officer stops you, it has to be documented. They don't just walk around the streets randomly choosing people to stop. It must be documented, and you're entitled to a copy of the document of the stop and search, whatever the case may be. So it's all there, and he has to be able to justify why he's done it. But as you say, that complying with the officer and engaging with the officer is a better word than complying.
Sure.
Just engaging with the officer, you'll be on your way within a very short space of time. Once they've got your name, address, date of birth, where have you come from, what are you doing, you'll be on your way, as opposed to most likely will end up in a scuffle. Everyone will be upset with each other. You'll find yourself in the back of a police van, down the custody in a short space of time, where you'll spend a good couple of hours.
At least.
At least a good couple of hours.
Okay, so let's move on then and go to the police station now, okay? So we've been arrested, we're at the police station. What are we expecting once we're there? We've been detained, arrested by the police, they've taken us to the police station. What are we looking at here?
Now, let's start by saying that the whole situation, the whole scenario in a police station in custody is surreal. You normally find yourself in the doldrums, in the dungeon, or the basement of a police station. It's normally, they're not the nicest of places. Been doing this for many years. It's still
not nice.
Not nice to go into. It's very cold. There's no character. There are some characters in custody, but the custody itself has no character. And now, if there are different categories of people, if I can use that term, the different ways in which they deal with people. So if you, for example, if you a foreign national, there are certain things that they have to do, certain rights that you have. And one is which, as a foreign national, you have the right for your embassy or the High Commission of your country to be told where you are and what the reason is,
Sure.
and to accept their assistance. So that's one. And secondly, you have the right to tell someone, not just the High Commission or your embassy. You have the right to tell someone where you are and that you're in custody and where in the country you are, based on what police station you're at. You also have the right to a solicitor or a lawyer. What I would impress on that is to make sure that whoever you get is an accredited, qualified duty solicitor. These are independent solicitors. They're not, despite the fact the police arrange for them to come and see you, they are independent from the police. It's again another national organisation, and all the police do is phone a number into a duty solicitor call centre. They work on rotas. There are thousands of solicitors throughout the country, and they work on a 8-hour rotating rota, and you'll get whoever's on duty for that time that you're arrested.
Sure.
You may have your own solicitor, and you can ask them to call your own solicitor who would then come along to assist you. But what I would impress to make sure whoever it is, if the police arrange it, it will be duty solicitor. Now normally they won't allow anyone into custody if it's not duty accredited in any event for a duty case. So yes, so you have the right to notify your embassy as a foreign national. You have the right to let someone know where you are. So in other words, you have the right not to be held in incommunicado, so in secret, hidden away from the world, no communication with anyone. That doesn't happen. You have the right to free and independent legal advice. Now, there's the word free. It is free at the point of contact, and independent, meaning not part of the police or part of the system. These are people that are in private practice. You also are entitled to a copy of the Code of Conduct. Now, the PACE codes, which is the Police and Criminal Evidence Act codes. Let's say, if you've got nothing better to do than to read that book, that's entirely up to you. I've yet to find a client who has taken up the offer of the police to read that book. But it is there, you're entitled to it. So you'll find yourself being booked in, brought in the custody area. You may be waiting, depends how busy it is. It could take from 5 minutes to 5 hours to get you in. Now, the PACE clock starts ticking when you're at the police station. It's a 24-hour clock, and they've got 24 hours in which to deal with you and to get you out again. The clock stops.
Can I just stop you for a minute then? That 24 hours, when does it actually start from?
When you get to the police station.
Okay, so you don't actually have to be booked in yet. Once you're physically there, then the clock starts. Okay.
Because they give the custody officer, the custody sergeant, usually, it's time of arrest, time of arrival, time you get authorised, detention is authorised.
Right.
And then there's this register, it's called the custody record, is then opened. And everything that happens with you or to you from that point onwards is noted in that custody record. Everything should be noted in the custody record. You'll be allocated a cell. They'll take your fingerprints, they will take your DNA, they'll take your photograph, and they're entitled to do that. If you resist, it'll be taken by force. That's the bottom line. And then again, you find yourself at the wrong end of an assault charge. And this time it may be not just the police officer, but detention officers, in other words, the custody staff that are involved. So my advice would be, don't. They're entitled to do it. Just let them get on with it. And the quicker you let them get on with their job, the quicker you'll get out. And the quicker you can get on with your life and then seek. If you weren't happy with the duty solicitor, that will come later, we'll get to that. You find your own lawyer if you want to. So once that's all done, so you've had your fingerprints taken, you had your photograph taken, you've had your DNA taken, and it's normally a mouth swab. That's all they do. And that's to one of the reasons they do that is to eliminate you from offences. It's not just to try and show that you've committed an offence, but also to eliminate you from offences. And that all goes onto a national database. Once you've been allocated to a cell, the case will be allocated to an investigating officer, and you'll just wait for your interview. Now that is where you'll get your telephone call. The custody officer is most likely ask you, is there anyone you'd like to call? The rules say that you can, I think it's, off the top of my head, there's 3 calls you can make. Not the 3 separate people,
yes,
but they give you 3 attempts.
Yes.
But if, for example, you've tried, your 3 friends or your mom, dad, and your cousin, and no one's answering, they will allow you. A lot of custody officers will allow you to continue. Maybe just not then and there, but come back later when it's not so busy or whatever the case is, and you can try again. So once you've made your phone call, allocated your cell, you just wait for interview. Now, before you go into interview, you'll be asked whether or not you want free and independent legal advice. A duty solicitor is another term for it. Or would you want duty? There's so many names for it. And if you say yes, they then make the call. You should get a phone call from the solicitor or from the legal representative of the solicitor's firm. They will discuss the matters with you. If the matter is warranted and it's serious enough, they may come down to the police station. 90% of the times, they come down to the police station to assist you in an interview. But some cases are quite trivial where they just advise you over the phone with what to do. So once you've spoken to the solicitor or the legal representative on the phone, you go back to your cell and you wait. You wait for the solicitor to come. the lawyer to arrive. Once the lawyer arrives, he gets or she gets disclosure from the police. In other words, the police say to them, this is why you were arrested, this is what the allegations are, this is the suspicion, this is the evidence thus far. Now, the police don't have to give you the evidence, but they have to say why you were arrested, where you were arrested. There are certain things they have to do, which is give you the basic details. They don't have to tell the solicitor or the lawyer, this is the evidence. Sometimes they may give you a snippet of the evidence and keep the bulk of it back to see what you say in interview.
Right.
And that's not unusual for that to happen. Once disclosure has taken place, then the solicitor, the legal representative, will have a private consultation with you. It's in a room, normally soundproof, or the police officers disappear in any event.
Yeah, I think sometimes there is a suspicion, sorry, Len,
there is suspicion
that the police are listening in, or it's not soundproof, or like you said with the duty solicitors, because sometimes they can be quite cordial, if you like, with the police officers, that there is some sort of conspiracy, or they're sort of too friendly, too pally with the police officers.
This is the misconception.
Yes.
Is that because these solicitors or duty solicitors and the police officers, they meet each other on a quite regular basis.
Exactly.
So they can be quite friendly, but I think, and I trust that once we get down to business, we take the friendly hat off and we put our solicitor's hat on, and then it's business only.
Yes.
So, but yes, gone are the days where they listen in and they spy on you. Gone are the days. I think when consultations are held in the interview room itself, and there's a microphone stuck to the wall or stuck to the table, that's where the suspicion comes in.
Yes.
But that works when the machine is on, and the machine only goes on once the interview, just before the interview starts. But as I was saying, you have this private consultation where you are given a disclosure, and the solicitor then gets your account, and that's one of the reasons why you're being interviewed by the police. It's for them to obtain evidence by you giving an account, in other words, your side of the story. They've said you've done this, your opportunity to say, I did or didn't.
Yes.
And that's basically what the interview is there for. It is under caution. So in other words, well, we'll get to the caution in a minute. You had your consultation with the solicitor. He tells you what the disclosure is, what the evidence is, what he or she knows at that point. Get your account, and then from your account, they will then make a qualified decision or advice.
Yes.
It's not their decision, it's advice that they give you to either answer questions the police put to you, not to answer questions that the police put to you, offer a prepared statement. In other words, you just give a snapshot of your account or an account in writing to the police. So those are the three main ways you can deal with an interview. Is you give a comment, give a no comment. I think that's most people know what the term no comment.
Yes, yes.
And then a prepared statement.
Yeah.
Okay. Now, after that, the officers are told they're ready, and the interview will start.
Yeah. Okay. Could you then? Is it possible for people to say to make the choice to say no comment, even though the solicitor or lawyer has advised them to actually answer the questions, and vice versa as well? Is it possible, if you've been advised, don't say anything, just go no comment, that you could decide yourself that,
yes,
no, actually, I'm gonna answer questions? And the reason why I ask that is obviously people are concerned about what their rights on, whether they're making their scenario or situation worse rather than better. And also because I have seen scenarios where people haven't answered questions at the beginning, but then once in a while do chip in a comment during an interview. So it's almost like it's not natural that if somebody's asking you questions that you would say, no, I'm not going to answer. Oh yeah, but I am going to make this comment, and I will answer that question and that one as well. But now you get to the really tough stuff. No, I've got no comment now.
It's not uncommon for that to happen. It's not very helpful.
Yes.
It's not very helpful to you by giving an account. As you said, the easy ones, I'll answer that. But when it comes to difficult ones where I'm in a bit of a sticky spot, no, it doesn't bode well for you at the end of the day. But what you've got to remember, and you will be reminded, if you do a no comment interview, the police will remind you, not once, not twice, numerous times, this is your interview. The solicitor can only advise you. So if you're advised to go no comment, to give no comment to the police, but you think, hang on, no, I've got an explanation, I've got a valid explanation, it's your right to then give the explanation. But if you're going to give an explanation, my advice would be is to give the full explanation,
Yes.
as opposed to just snippets to try and make yourself look good. But where the road gets a bit rocky, you say, no, I'll keep quiet on this. That's not going to be helpful. So ideally, it is you give a no comment or a comment or a prepared statement which just says, for example, you're accused of stealing a loaf of bread from the local Sainsbury's. Your name, I did not steal bread on this date from Sainsbury's, full stop. You've marked your...
at least you've said something.
You've nailed your master to...
Your colours to the mast,
colours to the
absolutely.
mast, sorry, and said, no, it's not me.
Yeah.
Or you say, it must be someone else, or whatever the case is. But when you start crisscrossing and chipping in and going no comment, it gets messy.
Yes.
And...
well, it also has bad implications, doesn't it, in the future? Because if you then are then charged with an offence and then you're in court and let's say you have a trial and that's where the interview is used, isn't it?
Yeah.
In the trial process. Or even when the CPS, so the Crown Prosecution Service, are considering whether to bring charges against you, etc., or what type of charges. All of this is weighed in the balance, isn't it? And because they'll be looking at all of this. So if you sort of ducked and dived the question, so you've answered one but not another, that in itself may be seen in a negative light in terms of how either the prosecuting authorities or the courts see your evidence and whether in fact you're a witness of truth and whether in fact the other side you've got something to hide.
Well, that's the essence of it. It's whether or not you're telling the truth, and that's what an interview is there for. One of the main reasons is to get to the bottom of the truth,
Yes.
to get to the bottom of, and to find out what the truth is. What you've got to remember is that at the end of the day, as you say, when this gets to court, if it's in a magistrate's court, there's going to be either a district judge, 2 lay magistrates, or 3 lay magistrates, independent from the process, from the interview. And you're sitting there listening to this, thinking, why has he answered the easy stuff? But when it gets, when there's the smallest amount of evidence to implicate him, no comment.
Yeah.
Or I don't remember.
Yes.
That won't bode well. Now, on the other side of that, is if it goes to a Crown Court, you're going to have 12 people that are going to be, well, the magistrates and district judges as well. They're going to be just applying common sense and logic.
Exactly.
Common sense will say, well, what's he got to hide? Unless he doesn't want to implicate himself.
Yes.
Or herself.
Yes.
And on that basis, you must probably find yourself at the wrong end of a decision or a conviction. The downside to, and this is very important with interviews and going no comment, is the concept of an adverse inference. Okay, which in essence all it is, it's a common sense conclusion. If you go no comment to questions that are pretty easy, and the officers normally start with, what's your name, what's your date of birth, where do you live, who's your mom, just no comment, no comment, no comment. And the questions will progressively get tougher as they get closer to the offence and to the truth of the matter. So I think the basis is if you've got nothing to hide, just tell the story. But if you go no comment, the adverse inference will be common sense conclusion. He had nothing to say because he couldn't say anything because he was going to implicate himself because he's guilty of this.
Yes.
And the adverse inference, the jury or the magistrates take the inference. They are the ones that are given or are asked to take the inference. Is that the common sense conclusion is little Billy there had nothing to say because what could he say? Because it's clearly him.
Exactly.
So that is the dangerousness of going no comment.
It's difficult though, isn't it, Leonard? Because again, scenarios, I keep, as we're talking and we're discussing this, I'm thinking of different scenarios in my mind in cases that I have done, where you've sort of had the no comment sort of scenario. And I remember one vividly where he went no comment throughout the interview, and then when it got to court, there was a video which I hadn't seen. I was defending on that occasion. I hadn't seen the video before until I got to court. So I saw a video and actually saw him stealing the item, in my opinion, stealing the item that had been accused of stealing, that he'd gone no comment on through the interview. So when I asked my client, well, what were you picking up? What was that? And he said something completely different. He said, well, it was X, Y, Z. And I said, well, if that's the scenario, why did you not say that during your interview? There didn't seem to me to be any sense in why he hadn't explained that to the police. Because now it's almost like we're on the back foot. We're now having to explain, as well as the jury sitting there thinking, why wouldn't you just say it? If it was as simple as that, you would have told the police.
Sometimes it's a tactical decision on behalf of the defendant.
Sure.
It's that if I say it was me, I did it, well, they'll charge me tonight, and I'll be in court tomorrow. But I've got other plans. I've got to meet X, Y, Z. I've gone to the movies or whatever the case is. No. So if I say no comment, they'll release me today. I'll see them in 6 months' time in court. I'll change my mind. It's not going to make any real difference. Now, that is also a concept that it was out there for a long, long time, but that has changed, and times have moved on. And we've got this early guilty plea credit system now.
Yes.
At courts, not at the police station. But if you assist at the police station, it also counts towards. It's taken into consideration with a sentence that if you assist the police and you open and honest and upfront to give a full account, that does assist if you're found guilty or plead guilty at a later stage. But yes, but at the end of the day, you do have the right to remain silent in an interview under caution. That is the first thing the officers have to say to you. You have the right to remain silent.
But then the rest of it is, but anything you do say, exactly.
Yes, will be taken down and it will be held and will be used against you.
Yes.
They say may.
Yes.
But it will.
Yes.
Yes.
I mean, that's the reality,
that's
isn't
the reality.
it?
It is used against you.
Yeah.
So sometimes, that is one of the reasons why sometimes you are advised to go no comment. Because at that moment in time, it may still be all up in the air and too messy to deal with at that moment in time. There needs to be a bit more evidence that may exonerate you. Or the police may say that you're the leader of the gang, where in fact you're right at the bottom. For example, they may accuse you of being a drug runner, when in fact you may be a courier, or you may be someone that has been, you're in servitude. In other words, you've been forced by other older people in a gang within the community to do work at their behest, in fear of being assaulted, your family being assaulted. So you may say, yes, I had the drugs on me, and yes, I was taking it from A to B to give it to, but in the meantime, we've got all this going on in the background. Now that may all be lost if we just say, yes, it's us, we done the drugs, we dealing the drugs. So sometimes it's better to get the whole picture, because the evidence may be non-existent. They may have very little evidence, and they're just going to see, they're going to test what you're going to say.
I call that fishing.
Well, yeah. And from there, the evidence starts, and it just starts unraveling. It's almost like a ball of a knitting. You pull it, and it starts unraveling. And you talked yourself into a corner already, and you just can't. It's on tape, and now it's also tape and video. You just can't get out of it.
Yeah, I mean, you raise a good point, then, because sometimes some of these no comment interviews are for legitimate reasons, aren't they? And it's because you may or may not have committed an offence, but there are other people within the triangle, within whatever group it is, that if you were to sort of free and easily tell the police all the information etc. they need, could have serious implications for you, other people in your family, etc. So there are lots of different dynamics, aren't there? So we shouldn't just assume because someone's got no comment, it must be because they're guilty. No, it's not. It's an informed, an educated, informed decision that duty solicitors make, and especially ones that have got. They don't make these decisions lightly. They don't, because they know it has ramifications for the person in custody. So it's not a decision that's just taken, just because I can. They weigh up the pros and cons, and it's experience and their expertise in this field that gives them that knowledge and understanding of, hang on, if we go no comment, it's not going to make much difference down the line in this specific case, but the ramifications outweigh the risk. Sure.
That's the thing. The ramifications of if he says something wrong, because all the police have to extract the smallest amount of information could then just blow up in your face. I mean, an example of that is someone that's accused of, say, theft from employer, for example, and he accepts, yes, I stole some money from my employer. Now the employer, looking and needing some money, goes back and has a check out and says, well, I may have said, okay, or I may have admitted to stealing 500 quid, for example, 500 pounds. And the employer goes back and checks his records, says, well, there's 50,000 gone. I've accepted I stole from him, so it must be me, all of it.
Yes.
All of it.
Yeah.
Now, the problem there is sentencing guidelines. So we've got the sentencing council that they bring out these guidelines, and they tweak them from time to time. Depending on how much money is stolen, would depend what the judge can do to you.
Yes.
So if you had £500, slap on the wrist, community order of some sort, £50,000, you're looking at custody.
Which
Yes,
means going to prison.
Yes, it means you're going to prison.
Yeah.
And that's the difference. And so when it comes to something like that, a scenario like that, the duty solicitor may say, well, let's go no comment now. Let's see how much they say you did steal.
Yes, indeed.
Because if we get to the magistrate's court in 3 months' time, and you say, well, yeah, I stole £500, and they can't prove any more than the £500, even if you took £5,000, you admit to the £500, because that's all they can prove, so be it.
You get punished on the £500.
You get punished on what they can prove.
Yes.
That's the bottom line. And a lot of the no comment is to test, like the police are testing you in the interview, asking you the questions under caution. No comment could be testing them and the evidence they've got.
Yes.
And at the end of the day, the test of time is proven by what happens to you, whether they release you under investigation, on bail, keep you in custody. And if they had enough evidence to keep you in custody to take you to court the next day, it would be out there, and your duty solicitor would have dealt with it. Yes. Yes, it's normally cases that are, to use a colloquial term, slam dunk. The cases that they've got you banged to rights, and you're not getting out of it. They've got your everything on CCTV, and they're showing you the CCTV.
Yeah.
So that's you, isn't it? That's you committing the offence. You can't deny it.
Yes.
Yes.
Yeah.
But normally it's released under investigation. You can continue on your merry way that evening or later that day, and you'll see the police on another occasion. That's not to say that the police won't call you back for another interview, a second or a third or a fourth interview. Okay, that is quite possible, dependent on which way the evidence goes and dependent on how serious the case is. But you do get people that have a series of interviews. Now, some of them can be over days, weeks and months. Some of them can be over hours. So you'd have one, have a break, have one, have a break, and so you go on. The more serious offences are normally one after the other. That's where the police are working against the clock, very quick time. You've got a group of people on the case, and as you're saying things, they've got people investigating what you're saying and feeding back into the interview, if you like.
Which direction the police go in with that information you've provided,
Because, I mean, they can't keep you, as I said, they can't keep you in there forever. Now, we spoke about the 24-hour clock.
Yes, that was going to be my next question.
Sorry.
That's all right.
That can be extended under certain circumstances. That an officer of the rank of inspector and above can extend it to 36 hours, and after that they have to get permission from a magistrate's court to extend.
Yes.
And then it's normally extended to 72 hours. And the decision has to be made either way. But these are normally cases that are very serious, very complex cases. And when they usually arrest you, unless it's something you've done and they've done then and there, and they've got the evidence to support it. And these are investigations that have been ongoing for some time, big conspiracies and such like, where the evidence is there, and it will be most likely to be overwhelming evidence, irrespective of what you do in the interview. The evidence is going to be there to some degree or another.
That reminds me of the recent case. The young lady that was I think, I don't know whether she was kidnapped or whatever it was, but certainly was taken by, as it turned out to be, a serving police officer recently, and then was found murdered somewhere in Kent. That reminds me of that case and how long the police officer in that case was detained for, because that certainly was more than 24 hours. Yes. And I believe that the police did have to ask for an extension of time in order to question him, because, of course, as you've already said, we're talking about murder, so the most serious of crimes. And at the point of him being arrested, no doubt it would have been, perhaps they were thinking about kidnapping and those sorts of maybe sexual assaults. Indeed, at that point. And then perhaps upon questioning him, that's how it seemed to be to me anyway, questioning him, then they receiving more information, then that's where they went out to Kent, start looking in certain areas in his home, in the grounds near his home, to try and find out and investigate, hang on a second, he's given us more information, let's go and search here. He's given us more information, we're now going to the woods. So do you remember that case? There was a lot of sort of progressive occasions where it seemed they were getting information from him, and that led the investigation to the various directions he was going. So that sounds to be in keeping with what you're saying.
Yes.
As somebody is giving the information to the police are then using that to then steer the direction of their investigation.
It's managed. I mean, it's not just one or two police officers that deal with that. It's, as you say, it's the most serious of offences, murder and terrorism offences, etc. Not to say that the lesser offences don't get as much detail. It's on a smaller scale. But something like murder, no one wants a murderer running around the streets.
No.
That randomly abducts a lady or a woman off the street, a young lady off the street, and murders her 50, 60 miles away from where she was taken. So that is everything what they call quick time. It's happening, and it's the communication between the officers and the interviewing team and such like is key, I think, to that. But as you say, is when they get to the point in the different stages of the interview, they make the applications to extend the time to make sure that they've got enough time to make sure it's not a never-ending clock. To make sure they've got enough time to charge him at the end of the day.
Because they could also, the other scenario is you could be interviewed, released after interview, then perhaps come back at another date.
Yes.
But the type of cases we're discussing now are the ones where it's quite intense, isn't it? Where there's a time pressure, a young lady's missing, we need to know what's happened because time is of the essence. Last time we saw her walking Clapham Common, next thing she's been accosted by a police officer, she's in a car, she's disappeared. Yeah. We need to know what happened to her, and we need to know quickly, because it may be that we're saving a life, it may be that unfortunately we're recovering a body. And in that scenario, the police will want to know which of these two are we doing, which is why they'd keep someone like that for a while and keep extending time as much as the law allows.
Yes. Now, the other side to that is, for example, let's say someone comes into the country on a visa, a visitor's visa, overstays, wants to settle himself or herself in the country, goes to see what is termed or goes to see what they believe to be an immigration advisor, pays a lot of money, gets given some documents sometime later, and these documents turn out to be false.
Yes.
They find employment, they do the CRB checks, the law catches up with them eventually, and they are arrested for possession of false documents with intent. Now, clearly we've got the police involved, we're going to have immigration involved, the UK Border Force.
Border Force, yeah.
Yes. Now, a scenario like that, it's most likely you will be interviewed, committed a criminal offence by having this document and producing it and using it to obtain work. So it's false. It's fraud by false representation. So the police are going to interview you, but you also most likely will end up being interviewed by the immigration authorities because of being an overstayer. Now, they are likely to have the documents in their possession, copies of everything, because that's how the story, this is how this offence has come to light. Somebody's complained, somebody's brought it to their attention. But it's not to say that you're going to be interviewed and taken off to court the next day. Is that you most likely will be released under investigation, and that could take anything from a couple of days, couple of weeks, couple of months. It could take a year. How long is a piece of string?
Yeah.
When you are released under investigation. And when you're released under bail or on police bail, they've got time limits again in which to bring you back, re-bail you, bring you back, re-bail you. Okay, that was something that stopped some time ago. So what they normally do is they bail you, bring you back, and then release you under investigation. But I think more commonly now, it's just once, if they haven't got enough to charge you, it's just for something as trivial as that. Even though it's not trivial, when I say trivial, I mean it's not murder.
Yes.
And you're not robbing banks. It's they release you under investigation as long as the police know where you are, and you keep in contact with the solicitor. So if they need you, they don't want to run around the country looking for you. They'll release you for however long it takes, and call you back. You may have more than one interview. You may have 2, 3, a series of interviews with the different authorities. And at the end of the day, the decision will be made to either charge you or to no further action you. The term they called NFA, no further action, which means is the case is over. But the misconception is, even though the case is over, that record of you being in custody will be there forever. That never goes away.
Well, that's the other thing, isn't it? Then, because then let's break this, I suppose, into two different directions. The first being that if you have been interviewed by the police, based on the evidence they have, whether it be through what you've said in an interview or rather what you haven't said in an interview, but also based on whatever evidence they have, physical or evidence or witness evidence they have, they decide to charge you at that point. What are the scenarios there? Because once you're charged, are you remanded in custody? Are you released? What's the process on that side?
Well, there's different ways in which to get you to court. They can either keep you in custody and take you to court the next day or the next court day. Courts, we sit on Saturdays, sit on public holidays. Just Sundays we don't sit yet.
Yes, exactly.
But they will take you to court, within the 24 hours. And they'll get you to court. They can requisition you, they can summons you to court. In requisition, in other words, they send you a letter to say on this time, date, place you need to appear in court. They serve it on your last known address. That's why it's important for your solicitor or the police to know what your last or your address is. As long as they serve it on your last known address, service is effective. In other words, the documents, you've received the documents legally. So that's why it is important. So those are the ways they can do it. They can either keep you in custody, take you to court the next day, or still release you and then just requisition you. A lot of times they release under investigation, they will just send you a requisition or send you a summons. There's normally a requisition now.
Because the thing is, if you don't, the reason why you mentioned last known address is if you don't turn up, we've now got, again, like we said earlier, another set of circumstances, haven't we? We've got another set of possible offences, bail offences, for example.
Bail offences, yes.
Yeah, sort of failing to surrender, failing to appear, all of those sort of things, which have their own implications. And you could go to prison for a day, could be fined, all sorts, for just that alone, regardless of the outcome, I have to say, of the original offence. Is that right, Len?
That's right. The Bail Act offence is a separate offence. It's separate to whatever you're going to be charged with. They'll put that to you. Now, in its own right, it's just as serious as whatever you've been charged with. It's to do with the course of the administration of justice. Bail Act offences, it holds everything up, and the courts take it very seriously. And as you rightfully say, that can result in you having your bail withdrawn. If the courts are then not satisfied that you will adhere to any other bail order, is that they will withdraw your bail, you'll go inside into prison on remand until your trial. Until your trial.
And that could be, and that could be just for that bail. Just for that bail issue.
Yes.
Even if your original offence would not have necessarily landed you in prison.
It's unlikely, but it's there.
But it's possible.
It's possible. It is possible.
Especially if you've someone who's got a bit of a record. I think those ones tend to aggravate what's gone on before. Tends to aggravate what happens next.
Once you've got the one record of failing to appear or failing to surrender, is that the next time it happens for whatever reason, they go back to that.
Yes.
Now they always refer back. As I said, your record is there for life.
Yes.
They always refer back to it.
Yeah. Can I just ask one question, actually, Len? As you said, records there for life. I know with a lot of clients that I have had that some of the belief, because of the DBS checks and things like that, or what's known as spent convictions, etc., at some point people think, oh, well, it's all right. Well, I committed that offence when I was 20. I'm now 45. It's irrelevant for all scenarios that I need to mention it, so I don't need to declare those offences or that offence. That's true in some ways, isn't it? But not true in others, because it's not wiped off your police record. I think that's the important thing, isn't it?
It's always there. It's just that when a conviction is spent,
which means it's sort of, once it's reached a sort of period where
really what it means is we're not going to hold it against you.
Sure.
That's basically what it means. We're not going to hold it against you. So if you, for example, go back to the example, you steal a loaf of bread, and then 3 years later you steal, or 5 years later you steal another loaf of bread, they're not going to hold it against you that, 5 years ago you stole a loaf of bread, or whatever the case is. But the more serious the offence, the less chances they won't, or that they will use it against you.
Yes.
For example, if you've got an offence of extreme violence, and 5, 6, 7, 8, 10 years later, you commit another offence of extreme violence, they will use it against you. That is called bad character. And I think that is something, again, something that can be discussed it's a topic on its own.
It is a topic on its own.
Quite a complex piece of legislation and area of law. But yes, if you've got previous convictions, they will always come up. Always come up. Unless they're trivial or they're not relevant.
Yeah. So I've seen ones 30 years ago mentioned. Yeah. Small, minor offences mentioned 30 years later.
But it depends on how you've behaved yourself in the 30 years.
Yes.
It's not to say that leopards don't change their spots. Sure. The law is there, the Rehabilitation of Offenders Act is there to allow the leopard to change his spots. It gives you the opportunity, and it's entirely up to you what you do with it, with your life. So if you're a young man and you were a rebel rouser and you went absolutely berserk with your young life, and as you matured, you led a normal life. And 30 years later, it just won't be fair, it won't be right, it won't be just for them to use that against you when you can show that for 30 years, from the age of 20 to the age of 50, I've done nothing wrong. I've had a good job, stable home, a lovely wife, kids, grandkids, whatever the case is. I was silly back then. That's the spin that will be put on it. Yes, he most probably was. So it won't be right to say, well, when you were 20 or 19, you did X. Now you're 50, you're still doing X.
You're as bad as you were when you were 20. That's not realistic, is it?
That's not right. No, that just won't be right.
Yeah. So we just talked about the interview, haven't we? So we've just talked about the scenario where we have an interview, and then after that possibly being charged. We've also talked about a scenario where you have an interview and possibly then being released. And perhaps just to pull all of that together, so you've got on one side release, on the other side you've been charged, or released pending investigation, or released completely without any further investigation. And on the other side you've got them being charged with an offence for whatever offence that is. You could also be released after being charged, couldn't you, with a date to then attend.
Yes.
Or after being charged you're remanded, which means kept in custody to then appear at a later date, as you say, either the next day or the next 2 days, whatever it is, at the local magistrate's court, and then you either then at that point will then plead guilty, not guilty, and then perhaps end up with a trial or not a trial, depending again on how these things go. So there are a lot of steps, aren't there, Len?
There are numerous steps, yes.
Yeah, and a lot of things that need to happen before we get to, if you like, the D-Day of a trial, and get to the point where you could end up possibly with a conviction or being found not guilty.
Yes.
Yeah, so it's just I think the purpose of today with you and I is to discuss with people and let people understand and know what their rights are at the point of being questioned by the police and arrest.
The arrest and the interview is step number one, or step one and step two, and they're very intricately linked with each other, and very close in time with each other. After the interview, things tend to drag. They take some time. But the main right you have once you've been arrested is, or once you've been taken into custody, is you have the right to remain silent. You have the right to solicit free and independent legal advice. You have a right to read the codes of conduct. It's the police codes of conduct, how they must behave with you, how they have to treat you. And as I said, you have the right to have someone notified where you are, that you've been arrested. You also have the right, if you are a foreign national or a Commonwealth national, you have the right to have your embassy noted. Now, if you are also a foreign national, you have the right to an interpreter. You have the right for questions to be put in your own language. And that is something that a lot of times isn't taken up by foreign nationals.
Yes.
And they find themselves in all sorts of trouble because the finer detail is lost in translation. And just the mannerisms of speaking, things are lost in translation.
Very much so.
Yes.
Yeah, I mean, I can give an example. I remember one of my, and this is not my case, one of my colleagues' cases, is a marriage of convenience. So marriage of convenience being that two parties have conspired together to get married, this was for immigration purposes. Yeah. And so the marriage itself was not a genuine marriage. And what then happened was that one of them was questioned in court about this marriage of convenience. Now, the word convenience, for us, most people, or some people I should say, know what that means when you say marriage of convenience. And the question that was put to this gentleman was, were you engaged in a marriage of convenience? That was the question put to him in English. And his answer was, as I'm told, oh yes, I was. It was very convenient. Do you see what I mean?
Yeah.
So he saw it as convenient in the sense it was very good, it was very nice, it was very positive. But luckily for him, the way in which he answered it made those in court recognise that maybe he has a different understanding of that word. But if he had perhaps said it in a different way, it may not have been picked up as him misunderstanding the meaning of the word, the phrase marriage of convenience. Do you see?
I see, and that's important as well, is that when you, in an interview and you have an interpreter with you, which is your right, is that to not be blasé about their presence, but listen intently. And especially if you do have some understanding of the English language, listen to what the police officer is asking, listen carefully to what the interpreter is asking of you, and the reply that you give to make sure that the interpretation is correct. And if it's not, then and there is the time to challenge it.
Yes.
To challenge the interpreter, then and there. And if you don't believe the interpreter is doing the job properly, or doesn't understand English properly, or doesn't understand the questions properly, or your answers, that's the time to say, you're not up to the job, and ask the police to find someone else. Or ask your solicitor to find someone else. Now that's the important point as well, which we missed, is that during the course of an interview, is that at any point in an interview with a solicitor, is that you could break the interview to consult with your solicitor at any point. So if the police are asking questions and you think you need to have a chat with your solicitor on some legal point or whatever the case may be, you just say, can I stop the interview? I want to talk to my solicitor. Tapes are switched off, officers leave, or you leave. Normally the police officers walk out, tapes are switched off, and you have your consultation, they come back in, and the interview continues. So that is an important point as well, is that if you don't believe that the person is translating things properly, time to say to your solicitor, don't leave it. By the time you get to court, it's too late.
Yes.
You should have challenged it then and there.
Well, because otherwise people think you're trying it on. You're not being truthful about it. Because if the interpreter's a problem, why didn't you say it before?
Because what you've got to remember, it's your interview. It's not your solicitor's interview or the interpreter's interview. It's your interview. It's your opportunity, and that's what the police will say to you from the outset. This is your opportunity to tell us your side of the story or give your account. And again, going back to no comments, they will say to you, this is your interview, it's only advice. They're not telling you what to do, they're advising you. You can take it or you can leave it. But at the end of the day, when this goes wrong, for whatever reason, should it go wrong, it's going to be you that's going to be holding the can. You are the one that's going to be answering to the judge and jury at the end of the day, or to the magistrates, not the lawyer.
Indeed.
Yeah.
Indeed. Thank you.
So it's always important to challenge something that's not right from the beginning. And even if evidence is not right, even if you're doing a no comment and the evidence is wholly incorrect, time to speak to your lawyer. So maybe that just needs to be challenged, because what you can do is then just give a prepared statement just on that aspect. If there's, like, for example, identification issue or something like that, you nail your colours to the mast. So it's not me. But as I say, my recommendation is never go into a police interview without a solicitor present.
Yes.
A duly accredited duty solicitor. I would recommend that. I can't recommend it enough. Don't say a word to the police until you've spoken to a solicitor.
Yes,
Don't say a word.
including in the police car, or van, or whatever, or at the point when the police are arresting you. Don't start making comments about the offence that you are being accused of.
What you've got to remember is that when the police arrest you, they will caution you. So immediately, what you say will be noted. In fact, if the police are talking to you and you say something, just an unsolicited comment, it will be noted down, okay, as a significant statement made by Mr. X. So everything you say will be noted down. Now, once they've cautioned you, whatever you say or do after that can be used as evidence.
Indeed.
Before that, it's just a significant statement which they should write down and give you the opportunity to read and sign that these are my words. I wouldn't sign, I would read it, I wouldn't sign it until I've spoken to a solicitor. But my advice is comply or work with the police, work with them when they stop you. Give them the information. If it's lawful. If they just randomly stop you, then maybe not. But if it's lawful and they give you the reasonable cause to ask for your details, give it to them. You'll find yourself on your way very quickly. If not, after that point, if they're saying, I'm detaining you, I'm arresting you, whatever term they use, as long as they make it clear to you that you're no longer free to leave, don't say a word. Don't say a word.
Yeah.
Okay.
Yeah, it's highly important.
Don't say a word. Don't resist them.
Yeah.
Don't fight. Don't struggle. Just go with them, and they'll deal with you, and they'll let you go, or whatever charge you as the case may be. So that's my advice when dealing with the police and with dealing with interviews. And that's not just with the police. That's also if you're called by the council, if you're called by the RSPCA, the Bird Society, whatever the case is, as long as they've got the power to interview, or they say, I want to interview you under caution, because that's what it'll be. They'll invite you in for an interview under caution. It'll always be there in bold writing. And if it's not in bold, read whatever letter you get carefully. The minute you see the word under caution, I need to find a solicitor.
Yes. Yeah, I think that's highly valuable advice, Len, that a lot of people no doubt would need, and a lot of people should be listening to. I hope you have, because this evening has been very, very interesting and highly informative. I want to thank you, Len, for coming this evening in order to support and assist me in supporting and assisting members of the public and those in the community to understand their rights, what your rights are, what are your legal rights if you're arrested, what happens at the police station, what should you or should you not be doing. These are highly, highly, highly important things that I think we all need to know, because it could happen to anybody. Whether the police are justified or unjustified in the arrest, it could happen to any of us. So again, I'd like to thank you, Len, for coming this evening, for talking with our viewers, for giving them your valuable information and advice. Of course, you are always advised to seek your own legal advice at the point that you need it, because of course we give you the best advice we can at the time on the day. But of course, as I always tell people, seek your own independent legal advice. Thank you for watching us. Please like, subscribe, share. It's highly important. This is Omega Live TV, bringing you the legal hour. Help your friends to know their right. Thank you so much, viewers, for joining us this evening. Hope you have a great evening, and we'll no doubt see you soon. Good evening.
I have known Chris over the last 5 years. He was my personal assistant some years ago. What I can say about Chris is he's very hardworking. He's meticulous, very detail-minded. He likes to think outside the box. You leave a work to Chris and you are sure you'll come back to meet your best. And we were working together nicely before he had this intention of starting his own business. He discussed it with me and I endorsed it and I let him go. And ever since I've been working with him, I disposed a couple of properties. I did it through him, and that was done in a record time. And I will always recommend Chris for anyone who wants to deal with properties, to deal with Chris and have the peace of mind and also have assurance that he will have the best deal.
Christian.
At World Remit, we understand what the journey is about. How it can sometimes take a little distance to bring us a little closer together. With ways to save more when you send more, World Remit is here for you, so you can be there for them.